When a marriage ends, the division of assets is one challenge, but the question of ongoing financial support, alimony or spousal maintenance, is often where emotions and finances collide most intensely. And if you think the rules are confusing in your own country, consider a couple where one spouse is from Germany, the other from California. They married in France and are now divorcing while one lives in Singapore. Which country's alimony laws apply? The answer is complex, but the first step is understanding that the very philosophy of spousal support differs wildly across the globe. In some places, it's a short-term bridge to self-sufficiency. In others, it's a lifelong entitlement based on the marital standard of living. Today, we're embarking on a comparative tour of alimony calculations around the world. We won't cover every nation, but we will dissect the major legal families and key jurisdictions to reveal the core principles, formulas, and cultural attitudes that determine who pays, who receives, for how long, and how much. This is not legal advice for any specific case, but a crucial map of the varied landscapes of postmarital financial obligation. Let's start with the foundational divide, the legal philosophy behind support. Jurisdictions generally fall into two camps. First, the clean break principle, strongly emphasized in England and Wales and many Commonwealth countries. Here, the goal is to financially disentangle the spouses as fully and finally as possible. Spousal maintenance is often seen as a last resort, awarded only when one party cannot meet their basic needs, and is typically time-limited to allow them to get back on their feet. The ideal is two independent financial units. Contrast this with the marital standard of living principle, prevalent in many U.S. states and parts of continental Europe. Here, the theory is that marriage creates an economic partnership. If one spouse sacrificed their earning capacity for the family, they are entitled to be maintained at a standard of living reasonably comparable to that enjoyed during the marriage, sometimes indefinitely. This philosophical difference sets the entire tone for calculation. Now, let's examine specific major jurisdictions, beginning with the United States. There is no single U.S. federal law, it's a patchwork of state laws. However, we can identify common pivotal factors courts weigh. 1. Length of the marriage. Short-term marriages under 5 to 7 years rarely yield long-term alimony. Long-term marriages over 20 years may result in permanent, often until retirement or remarriage awards. 2. Income disparity and earning capacity, the core of the calculation. Courts look at both current income and the potential to earn. If one spouse gave up a career, their future earnings may be imputed based on qualifications. 3. The marital standard of living, the benchmark for the recipient's need and the payer's ability to pay. 4. Age and health of both parties. 5. Contributions to the marriage, homemaking and child-rearing are valued. Some states have formulas like in Massachusetts or Texas, but most use these factors for judicial discretion. Crossing the Atlantic to England and Wales, the process is highly discretionary but guided by statute. The court's paramount consideration is the welfare of any minor child. Then, it seeks to meet the financial needs, obligations, and responsibilities of each party, with the objective of a clean break. There's no strict formula. The court conducts a detailed financial needs assessment, which includes housing needs, income needs, and pension provision. The recipient's need is balanced against the payer's ability to pay. Awards are frequently term-limited, especially for childless spouses, and the concept of sharing a future income stream is less common than a capital settlement, a larger lump sum from assets. In Canada, the approach is a hybrid. The core principle is compensatory support. It aims to compensate a spouse for economic advantages conferred on the other, e.g., supporting them through medical school or disadvantage suffered, e.g., lost career progression due to child-rearing. The Spousal Support Advisory Guidelines (SSAG) provide non-binding but influential formulas based on the length of marriage and the gross income difference. The formulas suggest ranges for amount and duration, but judges can deviate based on factors like need, self-sufficiency, and the harsh economic consequences of the marriage breakdown. Moving to Western Europe, we see nuanced models. In Germany, spousal support under halt is a need-based right but with strict limits. The primary goal is to enable the low-earning spouse to achieve financial independence. The need is calculated based on the marital standard of living, but the payer's obligation is capped at their capacity after meeting their own reasonable needs. Support duration is often tied to the length of the marriage. For a long marriage, it may be indefinite, but for shorter ones, it's typically limited to the time deemed necessary for retraining or job seeking. France has a distinct, compensatory model. The court can award a compensatory payment prestation compensatoire, usually as a lump sum or a fixed-term annuity, specifically to offset the disparity in living standards caused by the divorce. It is calculated based on the spouse's respective resources and needs at the time of divorce and the duration of the marriage. It is not meant to be ongoing lifelong maintenance. Finally, looking at Japan, the system is historically limited but evolving. Alimony is not automatic and is awarded far less frequently and in smaller amounts than in the West. The courts consider factors like the cause of divorce fault can matter, the financial needs and resources of each spouse, and contributions to the marriage. The duration is typically short, often just 1 to 4 years, and amounts are modest. This reflects different societal norms regarding postmarital obligation and self-sufficiency. Critical cross-border considerations. In international divorces, the first brutal battle is often jurisdictional forum shopping. Which country's courts get to decide? The choice of forum is perhaps the single most important decision, as the financial outcome under French law could be radically different from under California law. Spouses may race to file in the jurisdiction most favorable to them. This is governed by complex international treaties and rules of habitual residence. Furthermore, enforcement of a foreign alimony order is another hurdle, though international conventions like the Hague Maintenance Convention facilitate this between signatory countries. In conclusion, alimony is not a monolithic concept but a legal instrument shaped by deeply held views on marriage, responsibility, and gender roles. From the needs-based, clean-break approach of the UK, to the compensatory formulas of Canada, the lump sum model of France, and the limited awards in Japan, the global landscape is one of stark contrast. Critical international legal disclaimer: this video is for educational and informational purposes only. It is not legal advice. International family law is extraordinarily complex and fact-specific. The laws described are general overviews and subject to change. Jurisdictional issues in cross-border divorce are decisive and require immediate expert counsel. If you are facing an international divorce with potential spousal support issues, you must consult with a qualified family law attorney specializing in international matters in your relevant jurisdiction. Do not rely on this content for any legal decision. Understanding these differences is the first step in navigating the fraught, financially significant terrain of global spousal support. If this world tour of alimony laws was insightful, please subscribe. Let me know in the comments which jurisdictional approach you find the most surprising or equitable.